Well, it is interesting that it is not the executive precisely that has gone to court or the Senate. It is lawyers who are holding this debate, it would seem, and are convinced of certain things. And one will wonder how it will, hold up in court, especially with the issue of locus standi. However, you said that the Senate has said that the Senate is talking about an issue that is already in court. Now, the Senate is not talking about an issue that's already in court. They say that they are not confirming anyone because anyone not captured under 171 because of the stance of the executive. That this matter was brought forward over the confirmation, I think, of the chairman of the national, is it the DG of the National Lottery Fund, something to that effect. And they're wondering why that has been brought to their purview when it is not captured under 171 and the executive holds that decision or holds that opinion about their powers under 171. What are your thoughts on that?
Well, you see, what we have encouraged the executive or the legislature to do is to approach the court. And in any case, at this point, the Supreme Court is the court of first instance and the final court, as it were, when the two arms of government are disagreeing. As the situation now is that some lawyers have gone to court. And I must tell you, Magu, that the principle of locus standi, has been enlarged, quite recently. A lot of people now have access to court, so long as they can show that they are going to suffer some harm, with regard to any decision of government or any position, in governance. And I think that can be accommodated. But again, with regard to the legislature, I don't think that the appropriate thing for the legislature to do is to do a work to rule, because they are not National Union of Road Transport Workers, to begin to say if the legislature, the executive does not remove Magu or probably adhere to the earlier decisions they have taken, that they will stop working, because that's what it amounts to literally, I think that the best thing to do as it stands now is, over and above the fact that some people have approached the court, the legislature should approach the Supreme Court and let them have a final interpretation of this matter, and let us have a particular judicial decision on it that will guide us, going forward.
In your opinion, why the legislature? Why not the executive arm of government?
Well, any of them can, but as it stands now, it looks like it is the legislature that is aggrieved. So that is why we are saying that the aggrieved party should approach the court. Because if for any reason the executive is aggrieved, they should. It's the aggrieved party that oftentimes approaches the court. That is why I suggested the legislature, because instead of doing self-help, as it were, let them approach the court. Because what they are now doing, what they are trying to do is to twist the executive. That if you do not comply to our decision, and like I said, this decision is a pick and choose kind of decision. I have given you a situation where the legislature has approved the appointment or confirmed the appointment of 2 ministers. The Constitution does not allow the executive to continue to run, except and unless all the states in the Federation have representatives in the Federal Executive Council. But for about 2 years now, that Kogi State lost their representative in the Federal Executive Council. That slot has not been replaced. And the same thing with Gombe, which happened a while ago because of her appointment. But you notice that the executive has been going ahead, holding a Federal Executive Council meeting without representation from these 2 states. So what we are now saying is that if it is just not a pick and choose thing, why don't you just talk about the people we approved for you maybe recently? You have not sworn them in. And the person we did not approve, we find out that he is still working. So 2 of them can come together, as against a situation where you say, if Magu does not leave, that you will not approve any further nominations. And that keeps us worrying about why the legislature is worried about Magu.
Let me digress a bit. Doesn't the acting president have the powers to swear them in?
He does.
So okay.
He does. And like we have said, the acting president is the president we see today.
All right. So
with all the full powers.
About the Section 2.1 and 2.3 of the EFCC Act, where they say that he ceases or he has to be confirmed by the Senate. Does that then mean that those who drafted the EFCC Act were perhaps confused when they drafted
you see, oftentimes those are things that you also present to the court, to either interpret and put to rest, as it were. The EFCC Act says the chairman must be sent to the Senate for confirmation. But if the Constitution says that he is not one of the people that should be sent to the Senate in the first instance, the Constitution, of course, will be supreme to an act.
But you know that those who argue that that does not fall into that category of extra ministerial.
Beautiful. So the people who are arguing that Magu should be confirmed by the Senate are saying that EFCC does not fall under extra ministerial department. While those who are arguing that the EFCC the chairman should not have even been sent to the Senate for confirmation, are arguing that EFCC falls under extra ministerial appointment, which the president can appoint at his pleasure without having to go to the Senate.
Let's look at the polity. Excuse me. Let's look at what the polity is presenting to us as Nigerians now. It seems to be one that is heating up. Could the removal of Magu be a first line of orchestrated moves to subvert the Constitution, for instance, and possibly looking towards 2019 and having a presidency, hypothesizing now, having an Oshibanjo presidency?
I don't actually see the nexus, I don't see the connection, but politically speaking too, I don't see the nexus. But you see, what I see is a situation where there is a supremacy battle between the legislature and the executive. And something has to give. Some definition has to be made. And like I started by tracing where the problem started with, constituency projects. The legislature is not happy with what is happening with their constituency projects. And the executive is also not happy with the way they have smuggled them in. And to that extent, you notice that the suspended secretary to government ran into trouble with the legislator at a point in time when he said he wasn't going to disburse money for their constituency projects. That was in 2006 budget. And the legislature was very, very angry in the sense that the constituency projects is so dear to them. And it's not dear to them because of the constituency. It is dear to them because of what is there for them. I mean, let's call a spade a spade. That money is almost like a political booty that is being shared. Because if, for instance, we are looking at constituency projects from 18 years when we have had this dispensation, democratic dispensation, the whole country would have been awash with constituency projects. But what do you see? Some TV viewing center in one market square, what appears to be a health center that is not either funded or equipped by anything and all of that, and overgrown by weeds, and one water project that probably does not work after some 2 months, after commissioning and all of that.
Let me bring this matter.
That is where all these billions are going to.